Well, good morning, everybody. Hopefully everything's working okay. Let me just quickly check. Oh, hi, Kelly. Seems to be about a 20-second delay, maybe. Let's see. Yeah, there we go. Excellent. First of all, won't keep this too long, hopefully, because this evening, 9 o'clock my time, 3 o'clock Central Time, I'm going to be having a chat with the two young ladies that have started up a new channel, a new venture entitled Brendan Talks. So I'm looking forward to having a chat with those two ladies. So as I say, that's at 9 o'clock this evening. Hi, Jerome. Yes, I am slowly getting through that book. It's very, very interesting, going through all the different suspects. And once I get into it, I've had a lapse for a while, but once I get started, then I will speed up. I will get through the rest of the book very, very quickly. Okay, because I did notice a glimpse that you'd got scheduled for, I think it was towards the end of the month, this live chat, and we'll definitely be okay for that. Okay, Jerome. So look forward to that. Hi, Deborah. Hello. And so we've got Kelly and Jerome and Deborah. So as I was saying, live this evening, 9 o'clock my time, 3 o'clock Central Time. Going to go and have a chat with the two young ladies that have started a new channel, a new venture called Brendan Talks. I think you know who they are, but I'm looking forward to having a chat with them. I've got the next part from page 48 of Zellner's motion ready to go. But I just thought I'd make a quick comment on yesterday's video. Although I delete everything sent to me by the well-known cartoon character, it doesn't alter the fact that I still get the notification. The notification is still there. And looking at the little bit that he or she had written, it queried about the fact that even in the UK, serving police officers are allowed to be on the jury. Well, certainly not here in Scotland. And I'd like to start off by showing you this particular bit of information. So sorry to bust your bubble, cartoon character, but in Scotland, who is ineligible due to their occupation? People ineligible to serve on a jury include advocates and solicitors, apprentices of and legal trainees employed by solicitors, officers and staff of any court, constables of any police force, police cadets, members of children's panels. So, you know, definitely no way that you would ever have police on the jury here in Scotland. And I mean, it is ridiculous, isn't it, that you've got a volunteer officer of the Manitrok County Sheriff's Department who were described as having a conflict of interest. And then you've got one of these officers actually on the jury. It just beggars belief, doesn't it? I even wonder, did Dean and Jerry know that this person was a volunteer sheriff's officer? Was that part of the information that was given to them on the jury selection sheet? I would imagine not. Okay, so yeah, just to make it absolutely clear, there's no way in any civilized society that police officers should be part of juries, and particularly not in a case such as Stephen Avery's, where obviously the bone of contention is the planting by the Sheriff's Department, a frame-up, having been framed once before by the Sheriff's Department. There's no way anybody at all involved with Manitrock Sheriff's Department should be anywhere near Stephen Avery's case. End of. And that's made perfectly clear by Pete Bates, isn't it? Anyway, let's crack on with the next part of the look at what Kathleen Zellner has written. So, this is the argument. 1. The Circuit Court abused its discretion in denying Steve's motion to vacate its October the 3rd, 2017 order and allow additional scientific testing. On September the 18th, 2017, a meeting took place in Madison, Wisconsin, in which Kathleen Zellner and Douglas Johnson, the current post-conviction counsel, together with prosecutors Tom Fallon, Norm Ghan, and Mark Williams, reached an agreement regarding additional scientific testing. One, the RAV4 Wisconsin State Crime Lab Item A would be made available to current post-conviction counsel's experts, Dr. Carl Reich, Dr. Reich, and Dr. Christopher Palanek, who, of course, on the thumbnail I chose Palanek and Zellner, for a complete examination of the interior and exterior of the RAV4 for additional forensic evidence to be tested. The examination was to take place at the Calumet County Sheriff's Department. Normally we call it CASO because it's the Calumet and then Sheriff's CASO. There was a bit of confusion sometimes. You get MTSD and MTSO and CASO and CCSD. Anyway, we're digressing. The examination was to take place at the Calumet County Sheriff's Department, who has possession of the RAV4. In addition to gathering forensic evidence from the RAV4's interior and exterior, the agreement provided for collecting swabs for testing from the following items: battery cables, the bar under the driver's seat, hood latch, and interior hood release. The prosecutors also agreed that Steve would be allowed to do the following: A, conduct more sensitive DNA testing on the license plates, items A, J, and AK. Conduct DNA testing of the lug wrench. Yeah, that's often been suspected as being, could that have been the blunt object with which Teresa was bludgeoned? And C, Dr. Stephen Symes and Dr. Eisenberg, Leslie Eisenberg, would conduct a microscopic examination of the pelvic bones, 8675, discovered in the Manitrock County gravel pit to determine if they were human in origin. And yet they know already that those bones, that particular pelvic bones, those bones are no longer in their possession. When current post-conviction counsel inquired as to whether the circuit court, Angela, should immediately be informed of the agreement, Fallon stated that once he had finalized the scheduling of the RAV4 examination with Calumet, a stipulated order could be presented to the circuit court, similar to the original stipulated order for independent scientific testing that was presented by the parties to the circuit court and entered on November 23rd, 2016. Prosecutors stated that they would schedule the RAV4 testing in the very near future before the weather worsened. The parties also agreed that, at that time, they would propose dates for a potential evidentiary hearing. Neither side anticipated the Circuit Court filing its order prior to the time Mr. Avery could notify the court of the matters set forth herein. On October the 3rd, 2017, the Circuit Court entered an order dismissing Steve's 97406 motion for relief. On October the 6th, 2017, current post-conviction counsel spoke to prosecutors and informed them that Steve was filing a motion to vacate the October 3rd, 2017 order. Prior to filing the motion, current post-conviction counsel presented the motion to prosecutors, and prosecutors agreed to the factual accuracy of the representations regarding the content of the September 18, 27 meeting made in the motion. The state did not file an objection to the motion. The court did not issue its ruling until November 28th. The Circuit Court, once again, denied Steve's motion for relief from judgment. The parties were not required to submit proposals for further scientific testing for approval by the Circuit Court because of the prior order of the trial court entered on April the 4th, 2007. Therefore, the Circuit Court clearly abused its discretion when it denied Mr. Avery's motion for relief from judgment. Standard of review. An order granting or denying relief under Wisconsin Statute 80607 will not be reversed on appeal unless there has been a clear abuse of discretion. Under this statute, a defendant must first file a motion with the trial court to obtain relief from a judgment or order before appealing. Otherwise, the issue will be deemed unreviewable. It is undisputed that this statute governs civil actions. Lewandowski, for example, versus Calloway, and proceedings under 97406 are properly considered civil in nature. Rules of practice in civil actions apply in all criminal proceedings unless the context of a rule manifestly requires a different conclusion. So B, Angela, the Circuit Court erred in not complying with the prior trial court order regarding scientific testing. The original stipulated order for independent scientific testing was presented by the parties to the Circuit Court and entered by it on November 23rd, 2016. The order made express reference to and relied upon the trial court's April 4th, 2007 order on preservation of blood evidence and independent defense testing. In order to facilitate compliance with the order on preservation of blood evidence and independent testing, defense testing, and by agreement of the parties, the trial court entered the order in 2007, contemplating future scientific developments for DNA testing. The 2007 order provides in pertinent part 1. The state shall preserve indefinitely until further order of this court all bloodstains that the state believes contain Stephen Avery's DNA and that were found in or on Teresa Holbrook's vehicle in a condition suitable for further scientific testing. The defendant, Stephen Avery, or any lawyer representing him may at any time submit the bloodstains, swabs, and items described above to any laboratory or person the defence may choose for independent scientific testing pursuant to Wisconsin Statute 97123, without further order of this court. For purposes of illustration, not limitation, this paragraph expressly contemplates independent defence testing during any state or federal post-conviction proceedings, if any, or after any such post-conviction proceedings, emphasis added, without further order of the court. As demonstrated by Patrick Willis's order in April 4th, 2007, Steve was given the authority at any time to submit items of evidence for DNA testing. When current post-conviction counsel entered into this stipulated order in 2016 with the state, the testing items were expanded to include the key and the bullet FL. As discussed previously, the September 18, 2007 agreement between the parties expanded the items for DNA testing even further, but is compliant with the spirit of the April 4, 2007 order, which allowed Steve to seek additional DNA testing as DNA technology improved. Any DNA evidence from a complete forensic examination of the RAV4 would be consequential to Mr. Avery's conviction because the state's case hinged on the assumption that Steve's and Teresa's biological material, to the exclusion of all others, was present in the RAV4. If biological material from another individual with no innocent explanation for having been in the RAV4 is detected therein, that exculpatory evidence would create a reasonable probability of a different outcome in satisfaction of State versus O'Brien, because it would support the third party and frame up defences that Steve has advanced since before his 2007 trial. See State versus Denny. Exculpatory evidence detected on re-examination must be considered against the other evidence presented at trial to determine if it is reasonably probable that the movement would not have been convicted. Male DNA was detected on the RAV4 license plates, but was insufficient for a profile. However, with more sensitive and advanced DNA testing developed since the trial, a full profile may be detected, which would rule out Steve as the person who removed the license plates from Teresa's vehicle. And 5. Not 5, this is 29625. Since it is undisputed that the license plates were removed from Teresa's vehicle after her murder, the detection of a full DNA profile would be consequential to Mr. Avery's conviction and would satisfy O'Brien. And if Steve is excluded from the profile, it could create a reasonable probability of a different outcome. Pursuant to Wisconsin Statute 97407, a criminal defendant may move the circuit court for post-conviction testing when the movement can show that the evidence is relevant to the investigation or prosecution, the evidence is in the possession of the government agency, and that the evidence has not previously been subjected to DNA testing, or, if previously tested, may be tested using a newer technique. Wisconsin Statute 974072 provides that if the evidence has previously been tested, it may now be subjected to another test using a scientific technique that was not available or was not utilized at the time of the previous testing, and that provides a reasonable likelihood of more accurate and probative results. The Circuit Court clearly abused its discretion in not vacating its October 3rd, 2007 order in light of the explicit language of the trial court's 2007 April 4th order. Moreover, the parties reached an agreement in reliance on the Circuit Court's April 4th, 2007 order, which provided the parties with the authority to test forensic evidence without seeking any additional court order. Mr. Avery should be relieved of the October 3rd order because he has provided sufficient reason to justify that the Circuit Court reached an erroneous conclusion of law by not recognizing the existence of the April 4th, 2007 order. Because Steve's conviction was primarily based on planted forensic evidence, further forensic testing, as agreed upon by the parties, has more than a reasonable likelihood of yielding exculpatory evidence that is consequential to Steve's conviction and would create a reasonable probability of a different outcome. Yes, I think that's putting it very, very mildly. It is noteworthy that current post-conviction counsel has paid for all the testing done to date and intended to pay for testing performed pursuant to the parties' September 18, 2007 agreement, so no financial burden is imposed upon the state, although the state does have, I believe, an obligation to pay for testing if so required. It is a clear abuse of discretion for the Circuit Court to deprive both sides of additional testing, which will be performed at Stephen's expense. Yeah, it deprives both Steve and his family, Teresa and her family. 2, the Circuit Court abused its discretion in summarily dismissing Steve's second motion pursuant to Wisconsin Statute 97406 without addressing the 5 Brady claims raised and in subsequently denying Mr. Avery's motion to supplement, which raised a 6th Brady claim, all of which deprived him of due process in violation of the Wisconsin and United States Constitution. A standard of review. To establish a Brady violation, a defendant must demonstrate that 1, the prosecution suppressed evidence, 2, the evidence was favorable to the defense. Oh yes, here we go. Current post-conviction counsel has spent $292,000 on experts as of the filing of this brief, which of course it's a minute detail. It's a fraction of what the state has spent on the original case against Steve, and what has it spent since? Anyway, the evidence was favorable to the defense, and 3, the evidence was material to an issue at trial. State versus Harris, citing Giglio versus United States. This court reviews de novo whether the facts of a case establish a Brady violation. State versus Rocket, Strickler versus Green. There can be a due process violation, irrespective of the good faith or bad faith of the prosecution, quoting Brady versus Maryland. The prosecution's duty to disclose evidence favorable to the accused includes the duty to disclose impeachment evidence as well as exculpatory evidence. Yeah. The Circuit Court failed to address any of Stephen's 5 Brady violations filed in his motion to reconsider and its supplements, but concluded there is no argument or showing of a sufficient reason as to why these issues could not have been raised in prior motions. Without such sufficient reasons, these arguments are precluded from any subsequent motion. That was what the Judge Angela Sutkiewicz said. Okay, let's hold it there. We're up to about page 155, 156, and we'll start next with the Brady violation regarding Kevin Ramlow. And so just to say again, and hi everybody, tonight I realise this is not good timing for people in Australia to catch live, but maybe you can catch us later on in the morning tomorrow. But I am looking forward to having a chat with the two young ladies that have set up a new channel, a new group called Brendan Talks. So looking forward to a chat with them. And let's just go through who have we all got in the chat here. Imagine all the usual suspects, but let's just run through. Kelly, Jerome, Deborah, Mandy, Jerome, Andy, Deborah, Sean, Deborah, Sean, Deborah, Sean, Jerome, Millbilly. Yes, Millbilly. Particularly enjoying your. For some reason, I get notifications about 20 hours late, but I particularly enjoyed watching that TV interview of Steve by the one TV studio in Madison, and then the follow-up with Peg Lautenschlager. And I'm currently going through the presentation by Big Jeff, very good presentation on the deposition of it's Amy Lehman. Very, very interesting stuff. Very, very interesting. So, yep, keep up the good work there, Millbilly. Researching, yes, we know you do. T1, hi there. And Sean and Mandy and Sean and T1 and Joyce, Keith, hi Joyce, Kelly, Sean, yep, and Alice, Keith, Kelly, Millbilly. Oh, you've got a green screen. Excellent. What I'll do is I'll send you a picture that you can use anytime you like. In fact, I can send you a couple of pictures you can use anytime you like. Hi, everybody. So I'll leave it there. And if you're around this evening, 9 o'clock Scottish time, 3 o'clock afternoon time, Central time, as I say, having a chat with the two young ladies that have started up the new what's a green screen? It's what I've got behind me. I don't often do this, but here I'll show you what a green screen is. That's a green screen. No, let me put my studio back together. It just means I can come from, I can choose any picture. So, for example, I can go to Southern California. Okay, so anyway, look forward to a chat, as I say, with the two girls, the young ladies that have set up the Brendan Talks channel and group later this evening. Catch you all again soon. Bye for now.